Welcome to Tax Break, a podcast on the tax law brought to you by the lawyers at Miller and Chevalier. I'm Steve Dixon, a tax litigator with Miller and Chevalier, and I'm joined by my co-host, my colleague, international tax and tax policy expert, Loren Pons. We're going to stick with transfer pricing as the main topic for our third podcast in a row. And the last two episodes, we discussed the pending Facebook transfer pricing case in the tax court. Today's guest actually happens to be an expert witness in that case. We're obviously not going to discuss the substance of that case with him today. But our guest today is Dr. Michael Cragg. Mike's the principal and chairman of the Brattle Group, an economic consulting firm based out of Boston. Mike began his career as a professor of economics at Columbia University and at UCLA's Anderson School of Management, a pretty prestigious place where I've worked with several experts from the Anderson School. More recently, Mike has done economic consulting for a host of large corporations and government agencies and has often served as an economic expert in transfer pricing cases. We brought Mike on to discuss some alternative or maybe underutilized modes of reaching arm's length prices in the transfer pricing context. So, welcome to the podcast, Mike.
Thank you. It's very nice to join both of you, and I appreciate the opportunity.
So, the idea behind Tax Break is to provide listeners with some perspectives on select tax issues we think are interesting. We want to go deeper than what's in the tax press, but stay sufficiently high level so our listeners can follow along without a copy of the regs or, in this case, some economic textbooks in front of them. As always, first, a disclaimer: Tax Break is not intended to be legal advice, and you cannot rely on it as legal advice. Its content reflects only the thoughts and opinions of its hosts or guests. So, Loren, I want to sort of talk, since we're going to talk about some alternative or innovative modes of transfer pricing valuation, I wonder if we could kick it off by, you giving us you and Mike giving us some basics as to sort of what are the typical modes of transfer pricing valuation that we see in I guess sort of the lion's share of the easy cases.
Sure. So, for the uninitiated or the neophyte in this space, we can look to the regulations, which give us a little bit of a lot of information as to how to price certain transactions. And so, under the 482-4 regs for intangibles, there are several methods: cut and cup for kind of routine situations, the comparable profits method, CPM, and then there's also a reference to the residual profit split, which we use when the parties to the transaction each have non-routine intangibles to which they contribute to the transaction. And then further in the -7 regs, when you're in the context of a cost sharing arrangement, there are other methods for valuing the buy-in payment, as it used to be called, platform contribution transaction, as it is currently called. And so that's kind of an import of the concepts in the -4 regs, but also references some new methods: acquisition price method, market cap method, income method is probably the one that I have seen the most often. And so looking at what income you can be expected to generate from this contributed intangible, and then kind of discounting that amount back to the present to get to what you should value it as. And that is a non-economist definition of how to do a discounted cash flow. So Mike, feel free to put some more color on that.
Oh, I thought that was a great answer.
And so Mike and Lauren, I mean, when we have sort of a typical ordinary run of the mill transfer pricing question, I take it that there's a hierarchy of methods that are easier or even possibly more reliable, so that if you're in the instance of tangible assets, you may have some readily available cuts or cups that make things easy. Is that right, Mike?
Yeah, in general, the regulations, I think, are based upon the idea that markets are efficient and that they reflect competitive outcomes. And so when I think about what a routine transaction is one where you have readily observable markets, whether it be to identify a price or an alternative transaction, a royalty rate, all of those you see single purpose transactions which allow you to then with confidence measure what the an arm's length relationship would be for an intercompany transaction.
And makes it easy for the IRS to sort of get to the right price of tangible goods going across border.
Yeah, it's it's always very easy when you see single purpose companies out there. The I think the for economists and lawyers where the world gets complicated is when a corporation was formed in the first place to deal with all of the incentive and control problems that make it the more efficient outcome for profit maximizing firms. So it's the hard cases come up when the reason for the existence of the corporation is at play.
Right. And Steve, we should note that your reference to hierarchy is in terms of complexity and not preference, right? There is no hierarchy of methods in terms of which one is preferable in any given situation.
Right. It's the reliability of the methods depends on the the actual context, right? Whereas,
Right.
but in terms of if you're pricing a particular asset or service, uh, and you think that you can go out into the market and find a good comp, that's sort of your first course. I take it as an economist or even as a transfer pricing advisor.
Right, right. You still have to keep in mind the best method. So the best method is usually the one that's most easily and accurately applied, right?
Yeah, I think it basically follows scientific principles. What's going to
Mhm.
lead to the most reliable, most accurate outcome.
Yeah.
So, but by the time lawyers and certainly litigators like me get involved, and by the time we're retaining expert witnesses like Mike often does, we're usually talking about some sort of higher order question that's trickier. And today, Mike, we wanted to talk about a couple of things that that you sort of raised with me before, and that I thought would be interesting topics, um, which are sort of different ways of thinking about the modes of analysis and maybe some sort of underutilized thinking that hasn't made its way into sort of the main the mainstream of transfer pricing thinking. And the first you raised was sort of the kinds of economic analyses that happen in antitrust litigation and how those might inform some transfer pricing valuation. So you've done some antitrust expert work. Can you tell us a little bit about what the role of the economist is? We know the role of the economist in transfer pricing, right? It's to sort of get us to the right arm's length price. What's the role of the economic expert in antitrust litigation?
Yeah, and I actually think the roles are fairly similar, but using a quite different vocabulary. So, at the core of antitrust is the identification of is there market power, and did the company extend their market power either um, through additional transactions in other markets or restraints that they impose in other markets, or did they also coordinate with somebody in a legal manner? So it's all about is there market power, and how is that market power utilized? So that raises I raised three questions there. One is what's the market? So there's an economists define what markets are. Second, they then undertake the exercise of answering is there market power within that market, and then typically there's a dispute over some in litigation at least there's a dispute over some action the defendant took. which would have an anti-competitive effect. And so those are, I say, the kind of the three things that economists are doing: markets, market power, and effects.
And then so when you talk about sort of defining the market, I mean, that seems to me like something of a unique uh, or differentiator from what's happening in the transfer pricing context, in the sense that you're sort of your analysis isn't focused on narrowly on a particular sort of price of a particular transaction, but rather it's an analysis of sort of the broader market and what the mechanics of that market. Is that fair?
It can be, but not necessarily. So, in answering defining the market, often there's something utilized called the hypothetical monopolist test. And so you start with the subject product and then ask, could a monopolist in this particular market, narrowly defined, could they raise price? And they can only raise price when there isn't a competitive effect from substitutes for that product. And so you're kind of expanding the market up to the point where a monopolist doesn't face competition from another product. That's actually pretty important in the world of transfer pricing, because geographic markets are at the core of transfer pricing. And often there's a statement that someone will make about, oh, they can just open up put a plant here, or do something there, without recognizing that the geographic market actually plays a big role in defining what the price would be, and the intercompany price.
Yeah, Mike, that reminds me of kind of maybe 10 years ago or so, the arguments that some of the larger emerging markets were making in terms of the value of just being a player in their geographic market should kind of not dictate, but certainly inform the transfer price, the profit attributable to income that would stay in that market, right? So, marketing intangibles just really were attributable to the folks, the size of the market, the ability to be the first mover in that market. And I do think that conversation has kind of informed what's happening now with the digital economy work that the OECD is doing, and the power of certain companies to really exploit the market. In this case, remotely, but you know the market itself as the value driver.
Yeah, and the piece that is always at issue for economists in this market definition is the consumer.
Mm-hmm.
And so, if we take a consumer perspective on marketing intangibles, there the question is, well, what does the consumer actually know about a particular brand? So
Right.
obviously, the example I like to give, uh, my kids know what Jewel is, but when I ask them about the Marlboro Man, they don't. And so I'm obviously identifying my age here, but and so I don't know whether you guys know about the Marlboro Man, but it's such an iconic image that it's almost mystifying that our kids don't actually know it. And so that really, to me, reflects really well this idea of, well, what's the brand value that the Marlboro Man? Well, for 20
Nothing
year olds,
today.
it's
Yeah.
zero, right?
Yeah.
And that's because you couldn't make the investment in those consumers to make them aware of what that icon actually stood for.
Yeah.
Yeah. I mean, maybe could you talk about some of the sort of specific questions that you've had to address, and sort of as an economist in antitrust cases, and with an eye towards sort of how those those kinds of analyses might apply in the transfer pricing context.
Yeah, so one of the areas which has received a lot of attention in the antitrust world these days is about networks and platforms. And the concept of a two-sided market was created by the Supreme Court a couple of years ago. in a ruling called the Amex ruling, where they identified that a transaction market is two-sided, and you need to consider not only the consumers in defining the market, but you also need to consider merchants, the other side of a transaction. And they left open the question of, does that apply to all platforms? So they didn't answer whether you need to consider a game platform, for instance, as a two-sided market. Now, economists readily identify that there's a positive feedback from consumers, playing on many games, creating a network effect there that then has a feedback to the game designer, who then takes advantage of that and looks to create games, and that then has its own compounding network effect. Now, what's interesting when you then bring that to the world of tax is that the understanding of platform intangibles doesn't have the same level of rigor that you see in the competition world, because in competition economics, you're constantly asking yourself this question: what's a substitute? What's the barrier to entry? What's the competitive alternative? Which doesn't really come in when a taxing authority says, "Oh, this is a platform intangible." And so it's an interesting, to me, as a practitioner in both areas of the law. It's interesting to see where one has developed to in a way that should be complementary, but doesn't actually play kind of a role in educating decision makers in both contexts.
Loren, that sort of brings to mind the sort of realistic alternatives
I was thinking this
analysis.
exact same thing. Like, what are the barriers to entry? Can you do this on your own, or is it better to cost share with someone and develop it together? You know, the costs of not only the cost of doing it on your own, but the actual, can you do it? Is it even viable?
Yeah, exactly. I think in this realistic alternative perspective, it's interesting to compare a kind of a Chicago-style economist who sees competition everywhere to a neo-Keynesian economist that sees a lot of friction that arises in the economy from information and hence risk. And so, take the realistic alternative. Um, Often for a new product, the risk that's involved in building the market. Producing might be one thing. Building the market and the consumer's awareness can be very challenging.
So, Mike, it seems like, I mean, and Lauren, I think you'd agree with this, that while the realistic alternatives language has been in the regs for some time, it sounds like we haven't seen a lot of case law on realistic alternatives to this point, and we don't have a lot of guidance on what it means to sort of consider realistic alternatives. But what I hear you saying, Mike, is that there are lots of ways in which the kinds of problems that economists tackle in the antitrust context can inform that kind of realistic alternatives analysis.
Yeah, I think that's right. The other place that provides, I think, a useful context is in the world of um, uh, venture investing in private equity, which are um, not well understood to be happening at very different stages of a company's life cycle. So venture capital is typically taking a company that has developed a market, so they've overcome one of the major hurdles of actually getting the product off the ground, and then financing the growth of the company. Growth of the market is typically what is being invested in by a venture capitalist in terms of building up a sales force and creating customer relationships, and that's usually what the next stage of investment is made with venture capital. Sometimes it's in the context of, let's say, a bio pharmaceutical company. It's about creating information as it relates to whether a drug is effective or not. But in either case, it's kind of going through the stage of building a market. Private equity firm is often taking an entity where you see that there's a lot of inefficiency, and that you face the opportunity to either remove that inefficiency by having control, or you also see ability to combine aspects of one company in your portfolio with another company, so you can divide up your complementary assets to create value that way as well.
And so, do you think the ability or inability of a company at whatever point it is in its own life cycle to attract venture capital speaks to what their realistic alternatives might be? So your inability to attract capital, for example, might speak to kind of the where you are as a company, and whether people think you're actually viable or useful. And so you might be forced in some instances to cost share because you really can't do this on your own, as opposed to. But I feel like anytime you would get, even if you did get venture capital, it still speaks to your inability to do some things on your own because you can't afford it.
Right. I mean, a company is often expanding into a new geography. And the reason they don't set up, they can often set up a joint venture. So that's always, I should say, it's often in the mind of a partner of a company thinking about moving into a geography where they don't have experience. But the reason they might not do that is that they want to have control over how the asset is deployed, how it's developed, and then what the follow-on that comes from that. And so, if it's very predictable what the future is going to look like, then setting up a joint venture or licensing out the whatever it is that you're trying to develop, that becomes a straightforward transaction. It's much more difficult when there's going to be a lot of decision making along the way to develop the market and whatever the alternative geography is.
Loren, I think the realistic alternatives question is interesting in that venture capital context, but I wonder, Mike, if that also is a way of thinking about some of the platform contribution transactions that are the subject of the -7 regs, in the sense that if you have a technology that it's in its infancy, or a product or some kind of intangible that's in its infancy, that venture capital model might be a sort of a mechanism for pricing a transaction like that more accurately than some sort of other analysis. Does that sound reasonable?
I mean, it could be. There's in terms of what goes into that, then identifying what the potential growth rate looks like becomes really important, because typically a venture investment's only made for 5-7 years. They're looking to get a large return, and so they're typically only going to be investing in things where there's potentially a high growth rate, and so that becomes an important question. And then the other part of it that becomes equally important is what the competitive alternative is. And where you are in the platform development speaks to probably less about the technology and more about the consumer awareness of that technology and its compatibility with other aspects of the market. So,
and sort of the reliability with which you can make growth predictions in that
exactly,
context.
yeah. And so that the income method becomes, I think, quite interesting in that context, because you do for instance, if you look at a typical damages scenario in a securities matter, or a broken transaction matter where someone right now there are a lot of cases where you're drawing on material adverse event clauses.
Hmm.
Much of that involves the question, well, what were the growth prospects of this company? And so there's a lot of development of evidence on that question, which you don't quite see that same degree of rigor placed in a transfer pricing matter, even though, for instance, the dollars are often substantially larger, and the resources that are put into the litigation are very large. So it's interesting where as you look across different aspects of law, what the evidentiary requirements are by area.
And what's the sort of additional rigor that you would see in in the antitrust context that or in that sort of broken transaction context that maybe could be brought to bear in the transfer pricing context?
Well, there's a there's a lot that's done on what the contemporary uh, market looks like. And so whether, inside of both of the companies at issue, as well as what's happening outside. And so uh, I would say there's a greater appetite for drawing on kind of what exactly the world looks like at that point in time. And there's less of that I would say that's done at the point of a cost sharing agreement, for instance. If you drill in on the actual dates, the actual timing matters a lot in these broken transaction type cases.
Yeah, it just sounds like a more holistic approach
It
to
is. It does sound that way, but it's also because you're looking backward, right? So you've already had the event that made the transaction break. Whereas
Yeah,
in a cost sharing context, you're trying to, in some ways, foresee, what's going to happen, but you have a snapshot as of the day you enter into the cost sharing arrangement and price the buy-in that, this is what we think is going to happen. Um,
yeah, and on that is one of the things that I've been surprised at as a transfer pricing practitioner is that there's a very wide range of approaches taken to preparing documentation.
mhm,
Uh, I'm sure Steve is well aware of what that range looks like, but there are tax directors who generate a lot of value for their companies because they think of a creative transaction, but most importantly, they put together the contemporaneous evidence
right.
and the contemporaneous contracts so that it has a much greater sense of reality than just somebody kind of. I'm struck sometimes that you'll have a multi-billion-dollar transfer pricing deal written on two pieces of paper. Uh, the amount of risk that is put in place there is huge, but it's understandable because the audit's going to take 3 years and another couple of years after that, and you're basically at the end of the CFO's career by that point, and he doesn't care. So it's
Yeah, or and the tax director sees there being some risk in assembling a mass of evidence
May
that
not, yeah.
they may not understand.
They may,
yeah. So I don't know. Should the court draw a negative inference then, Steve?
I hope not. Um, so let's move to another concept that you talked about before, which is this notion of a minority discount and how a
Hmm.
minority discount might be informative in some transfer pricing context. So first, maybe if you could explain what that means, what a minority discount is.
Yeah, so from an economist perspective, the minority discount is looking at how markets discount transactions where there isn't really a lot of control that's transferred in the transaction. And so you often see, for instance, that, when one company is taking over another company, that there's a premium that's paid for that control that they get to take advantage of it. The hard thing in that second example is identifying what is the source of the premium, and is it going to be kind of synergies, which is the euphemism for cost cutting? Is it complementarity, where you're bringing together two assets, which is like the Reese's peanut butter cup example. Is it better together? And so there's there's this notion that the minority discount is easily calculated, but as soon as you kind of go into the real world and actually look at what happened in transactions, it typically becomes quite hard quite quickly.
And so, with this concept of minority discount, how do you sort of see this playing in the transfer pricing space? How can economists use those notions in getting to the right arm's length price?
Yeah, I think it gets to this question we were just talking about, which is what decision rights are involved in the creation of the transfer pricing transaction that's at issue. And control then becomes an important element of analyzing what the pricing should be,
or lack thereof.
or yeah,
So
exactly, yeah.
if you are the controlled party, you might not have as much license to say, you're less powerful in the transaction, and so
Yeah, and one of the aspects here that I think the world's really struggling with right now is, how do you identify control within a corporation, and is it associated with headcount, for instance, or is it associated with clear decision rights? And I think as we go forward with kind of new transfer pricing documentation, this notion of control is probably a good one to document, as opposed to just leaving unstated.
Right. It's kind of, I think it's implied, a lot of times, because you're dealing with subs and, or headquarter costs that you're pushing out. And so it's implied that the other parties are the controlled parties in that situation. But I think you're right.
Yeah, yeah, and as I was going back to this example of kind of a tax director who creates value, their focus on that kind of question,
Yeah.
and then going to the really important next step, which is talking to the business people and getting them to actually implement the transfer pricing strategy within the company's managerial accounting system, their business policies. That makes a really compelling case. Steve, I'm sure you find that the hardest cases are ones where the transfer pricing doesn't line up with the business economics.
Right. The policy is one thing, but then, the group in Italy, the local country CFO does it this way, and that's just how it is.
Yeah, exactly. Yeah.
Yeah, it is crucial and difficult to sort of match up your functions with and sort of the reporting lines with the actual with the actual sort of transfer pricing structure.
Yeah,
Um,
exactly.
and Lauren, that sort of brings us to some of the notions that BEPS 1.0 was really trying to get at, was how do we get to these sort of DEMPI functions?
Right. Who's doing what and where, as opposed to what's, let's say, on paper.
Right. And I take it, Mike, that there's ways that economists can sort of distinguish scenarios where a minority discount makes sense from those where it doesn't, and that is a sort of a mechanism for locating control within a group.
Yeah, that's true, and exactly. And then in terms of benchmarking the discount, there's an important task of saying what's a relevant comparable transaction. Many of the you see a for smaller both smaller transactions and in other parts of the implementation of the tax code, minority discounts kind of get, I hate to say it this way, but they kind of get slapped on, right? Without actually asking, is this comparable? Whereas in this notion of comparability is at the heart and soul of transfer pricing.
Mm-hmm.
Well, Mike, this has been fascinating, and we really appreciate you coming on. So thanks for your insight.
Well, thanks. I've been very much enjoyed talking with the two of you. It's always unpredictable, and it's always.
And for our listeners, if you have topics and ideas, please feel free to email us. You can let us know at podcasts@milchev.com. That's podcasts plural at milchev.com. Thanks, Mike. Thanks, Loren.
Thank you.
Thank you.